Welcome back, everyone. Let me start with a question that UPSC asked in 2021. What is the current status of the right to property in India? Most students hesitate. Some say fundamental right. Some say legal right. Some say neither. The correct answer, it is a legal right under Article 300A in Part 12. It was removed as a fundamental right by the 44th Constitutional Amendment Act of 1978. If you got that right, excellent. If you didn't, this video is exactly what you need. Chapter 7, Fundamental Rights. The longest, the most detailed, and the most tested chapter in the entire Laxmikanth. By the end of this video, every article, every case, every amendment, and every trick point will be crystal clear. Let's begin. Introduction to Fundamental Rights. What are fundamental rights and why are they fundamental? The fundamental rights are enshrined in Part 3 of the Constitution, from Articles 12 to 35. The framers of our Constitution derived inspiration from the Bill of Rights of the United States Constitution. In fact, Part 3 of our Constitution is rightly described as the Magna Carta of India. Now, why are they called fundamental? First, they are written in the Constitution itself. Second, they are essential for the personality development of every individual, material, intellectual, moral and spiritual. Third, Parliament cannot make laws against them. These rights are meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule. They protect the liberties and freedoms of the people against arbitrary state action. In short, they establish a government of laws and not of men. Originally, the Constitution provided for 7 fundamental rights. Today only 6 remain because the right to property was removed by the 44th Amendment Act of 1978 and made a legal right under Article 300A in Part 12. 6 fundamental rights are: right to equality, Articles 14 to 18. Right to freedom, Articles 19 to 22. Right against exploitation, Articles 23 and 24. Right to freedom of religion, Articles 25 to 28. Cultural and educational rights, Articles 29 and 30. Right to constitutional remedies, Article 32. The features of fundamental rights span Articles 10, 16, 19, 29 and 30. These are the articles that are available only to citizens and not to foreigners. UPSC has directly asked which articles apply to citizens only and which apply to all persons. Now let us understand the key features of fundamental rights. UPSC loves asking these directly. Feature 1. Some rights are for citizens only. Others are for all persons including foreigners. Feature 2. They are not absolute. The state can impose reasonable restrictions. But whether the restriction is reasonable, that is decided by the courts, not the government. Feature 3. All fundamental rights are available against arbitrary state action. However, some are also available against private individuals. For example, Article 17 on untouchability and Article 23 on forced labor, these can be enforced even against private individuals. Feature 4. Some are negative, they place limitations on the state. Others are positive, they confer certain privileges on persons. Feature 5. They are justiciable. You can move the court for their enforcement. Feature 6. The Supreme Court is their defender and guarantor. The aggrieved person can go directly to the Supreme Court under Article 32, not necessarily through a high court. Feature 7. They are not sacrosanct. Parliament can curtail or repeal them, but only by a constitutional amendment and cannot destroy the basic structure of the Constitution. Feature 8. They can be suspended during national emergency, except Articles 20 and 21. These two can never be suspended. Feature 9. This is a very important and frequently tested trap. Article 19 can be suspended only when national emergency is declared on the ground of war or external aggression, not on the ground of armed rebellion, which is internal emergency. Feature 10. Scope limited by Articles 31A, 31B and 31C. These are exceptions protecting certain laws from challenge. Feature 11. Fundamental rights of armed forces, paramilitary forces, police forces, intelligence agencies can be restricted or abrogated by Parliament under Article 33. Feature 12. Most fundamental rights are self-executory. But some need Parliament to make enabling laws. Such laws can be made only by Parliament, not state legislatures, to maintain uniformity under Article 35. What is state? Article 12 defines what state means for the purposes of Part 3, Fundamental Rights. The term state includes 4 categories. First, the Government and Parliament of India. This means both the executive and legislature of the Union Government. Second, the government and legislature of states. This means the executive and legislative organs of every state government. Third, all local authorities. This includes municipalities, panchayats, district boards, improvement trusts, and so on. Fourth, all other authorities. This is the most important and frequently tested category. It includes statutory bodies like LIC, ONGC, SAIL and also non-statutory authorities. The Supreme Court has extended this even further. According to the Supreme Court, even a private body or an agency working as an instrumentality of the state falls within the meaning of state under Article 12. This means the actions of all these bodies can be challenged in court as violating fundamental rights. Article 13, Laws inconsistent with fundamental rights. Article 13 is the guardian of fundamental rights. It declares that all laws which are inconsistent with or in derogation of fundamental rights shall be void. The term law under Article 13 has a very wide meaning. It includes permanent laws, acts of parliament and state legislatures. It includes temporary laws like ordinances issued by the president or governors. It includes delegated legislation, rules, regulations, bylaws and notifications. And it includes custom or usage having the force of law. Now an important distinction. Constitutional amendments are not law under Article 13. This was established in the Sankari Prasad case of 1951. Parliament has the power to amend fundamental rights. But Keswananda Bharti case of 1973 added a critical condition: a constitutional amendment can be challenged if it violates the basic structure of the Constitution. Article 13 also expressly provides for the doctrine of judicial review. It empowers the Supreme Court under Article 32 and the High Courts under Article 226 to declare any law unconstitutional if it violates fundamental rights. The main objective of Article 13 is to secure fundamental rights by giving constitutional provisions precedence over laws made by Parliament and state legislatures. Right to equality. Articles 14 to 18. Article 14 guarantees every person equality before the law and equal protection of the laws within the territory of India. Note, this applies to all persons, not just citizens. It includes companies, corporations, and societies, legal persons. Now, two concepts are embedded in Article 14. The first, equality before law. This is of British origin. It is a negative concept. It means the absence of any special privileges. No person is above the law. Every person is subject to the ordinary law of the land. The second, equal protection of laws. This is of American origin. It is a positive concept. It means equal treatment. Under equal circumstances, similar persons should be treated similarly without any discrimination. From the handwritten notes, the state can treat unequals differently as equal protection of law guarantees it under Article 14. There are reasonable classifications varying to the needs of different classes of persons with the objective of creating a level playing field in social, economic and political space. But among equals, the laws should be equally administered. Now, rule of law. A.V. Dicey propounded three elements: absence of arbitrary power, equality before law, and primacy of individual rights. However, the third element, primacy of individual rights, does not apply in India because in India the Constitution is supreme, not individual rights. Article 14 also permits reasonable classification, but classification must not be arbitrary, artificial or evasive. Exceptions to Article 14, the President and Governor enjoy immunity under Article 361. MPs and MLAs enjoy parliamentary privileges under Articles 105 and 194. Foreign diplomats enjoy diplomatic immunity. Article 15, Prohibition of discrimination. Article 15 prohibits the state from discriminating against any citizen on grounds only of religion, race, caste, sex or place of birth. Note, Article 15 applies only to citizens, not foreigners. The word only is critical. The state cannot discriminate on only these grounds. But classification on other grounds is permitted. Article 15, 2, prevents even private individuals from discriminating on these grounds, making it a horizontal right. Now, the four exceptions. Protective discrimination. Article 15, 3, the state can make special provisions for women and children. This is an exception, not a violation. Article 15, 4, the state can make special provisions for advancement of socially and educationally backward classes, scheduled castes and scheduled tribes. This clause was added by the first Constitutional Amendment Act of 1951 following the Supreme Court judgment in the state of Madras versus Champakam Dorairajan case. Article 15, 5, added by the 93rd CA of 2005 allows reservation in admission to educational institutions, including private and unaided, for SCBCs, SCs and STs, exception, minority educational institutions. Article 15, 6, added by the 103rd CA of 2019 allows up to 10% reservation for economically weaker sections in educational institutions. This 10% is in addition to the existing reservations. Based on the Singho Commission recommendation. Exception, minority institutions. Article 16, Equality of opportunity in public employment. Article 16 provides for equality of opportunity in matters of public employment. Appointment to any office under the state applies only to citizens. Article 16(2) prohibits discrimination in public employment. Note the grounds include descent and residence in addition to religion, race, caste, sex and place of birth. Now the exceptions. Article 16(3) Parliament can prescribe residence as a qualification for certain posts. The Public Employment Residence Act 1957 was enacted but lapsed in 1974. Article 16(4) The state can make reservations for any backward class not adequately represented. Limited by Article 335 Administrative Efficiency. Article 16(4)(a), added by 77th CA 1995, allows reservation in promotions for SCs and STs with consequential seniority. Article 16(4)(b), added by 81st CA 2000, the carry-forward rule: unfilled vacancies in any year are not counted in the 50% ceiling for that year. Article 16(6) EWS reservation in public employment, 103rd CA 2019. Now, the Mandal Commission story. The VP Singh government in 1990 declared 27% reservation for OBCs. This led to a massive controversy and agitation. The Supreme Court in the famous Mandal case, Indra Sahni vs. Union of India 1992, upheld the 27% OBC reservation but gave critical conditions. 1. Creamy layer should be excluded from OBC reservation. 2. Should not exceed 50%. 3. No reservation in promotions. 4. Carry-forward vacancies should not violate 50% ceiling. 5. A permanent statutory body should examine complaints of over-inclusion and under-inclusion in the OBC list. Article 17 and Article 18. Article 17 abolishes untouchability and forbids its practice in any form. Untouchability has not been defined in the Constitution or in the Protection of Civil Rights Act. However, the Mysore High Court held that it refers to the social disabilities imposed on certain classes of persons due to their birth. Article 17 is enforceable against private individuals. It has horizontal application. This makes it different from most other fundamental rights, which are primarily against state action. Enforcement is through to laws. The Protection of Civil Rights Act 1955, which punishes practices like temple denial, goods denial, forced labor, forced scavenging. The SC and Cent Prevention of Atrocities Act 1989, cognizable, non-bailable offence, no anticipatory bail, no preliminary inquiry mandatory for FIR registration. Subhash Kashyap Machi case 2018 banned anticipatory arrest in SC Cent Act cases. And Prithvi Raj Chauhan case, SC upheld the SC Cent Act 1989. Now Article 18 Abolition of titles. The state cannot confer titles, except military distinctions like Param Veer Chakra or academic distinctions. Indian citizens cannot accept titles from foreign states. Hereditary titles, Maharaja, Rai Bahadur, Khan Bahadur are banned. But national awards, Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri are not titles under Article 18. However, they cannot be used as a prefix or suffix to the name. They were upheld as constitutional in the Balaji Raghavan case of 1995. Maximum Bharat Ratna per year is 3. Right to freedom Articles 19 to 22. Article 19 guarantees 6 freedoms to all citizens of India. Note carefully, Article 19 applies to citizens only, not to foreigners and not to companies or corporations. Let us go through each freedom. Article 19, 1(a), freedom of speech and expression. This is the most important. It includes freedom of the press, right to propagate views, right to telecast, freedom of silence, freedom to demonstrate but not to strike. From the handwritten notes, it includes internet access as well. And importantly, freedom of voting is different from right to vote. The Supreme Court in the Sakal Papers case held that freedom of speech includes freedom of the press. Restrictions on 19, 1(a) sovereignty and integrity of India, security of state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, incitement to an offence. Article 19, 1(b), freedom of peaceful assembly without arms. Includes meetings, processions, demonstrations. Can be exercised only on public land, does not include the right to strike. Restrictions, sovereignty and integrity of India, public order. Article 19, 1(c), freedom to form associations, unions or cooperative societies. Cooperative societies were added by the 97th CA 2011. Includes the right not to join any association. Restrictions, sovereignty, public order, morality. Article 19, 1(d), freedom to move freely throughout India. Internal movement only, external movement is covered by Article 21. Restrictions, general public interest, protection of scheduled tribes. Article 19, 1(e), freedom to reside and settle in any part of India. Restrictions, general public interest, protection of scheduled tribes. Article 19, 1(g), freedom to practice any profession or occupation, trade or business. Does not include immoral or dangerous activities. State can run a monopoly in any trade. Restrictions, general public interest. Article 20 Protection in respect of convictions for offences. This applies to all persons, citizens and non-citizens, including companies and corporations. 3 provisions. Article 21 No ex post facto law. This means no person can be convicted for an act that was not an offence when it was committed. And no person can be given a punishment greater than what was prescribed at the time of the offence. Important limits: this applies only to criminal laws, not civil laws. And it provides no immunity in case of preventive detention. Article 22 No double jeopardy. No person shall be prosecuted and punished more than once for the same offence. Key limit: this applies only to proceedings before a court or judicial tribunal, not to departmental or administrative proceedings. So a government servant can be tried in court and also face departmental action for the same act. Article 23 No self-incrimination. No person accused of an offence shall be compelled to be a witness against himself. This applies only to criminal proceedings, not civil proceedings. It covers oral evidence and documentary evidence. But, and this is a direct UPSC question, it does not cover compulsion to give thumb impressions, specimen signatures, blood samples, or compulsory body examination. From the handwritten notes, narco tests, drug mapping, brain fingerprinting, and lie detector tests all are unconstitutional if involuntary. And even voluntary narco test results are inadmissible in courts. This was ruled by the Supreme Court in the Selvi vs. State of Karnataka case of 2010. Article 21 Protection of life and personal liberty. This is the most expanded fundamental right in the Constitution. No person shall be deprived of his life or personal liberty except according to procedure established by law. Applies to both citizens and non-citizens. From the handwritten notes, Article 21 protects not just mere animal existence, it includes life with dignity. Now, the judicial evolution of Article 21. In the A.K. Gopalan case of 1950, the Supreme Court took a very narrow view. It said Article 21 only protects against arbitrary executive action. As long as there is a law, even an unjust one, the state can deprive a person of life and liberty. Then came the landmark Maneka Gandhi case of 1978. This completely changed everything. The Supreme Court held that Article 21 protects against both arbitrary executive action and arbitrary legislative action. It introduced the concept of due process of law. The law must be just, fair and reasonable. The procedure itself must be examined for fairness. This brought India closer to the American standard. After Maneka Gandhi, Article 21 expanded dramatically. Some of the key rights under Article 21: right to live with dignity, right to livelihood, right to shelter, right to health, right to clean environment, right to education up to 14 years, right to free legal aid, right to speedy trial, right to privacy, right to travel abroad, right to fair trial, right to marry person of one's choice, and many more. From the recent developments in your notes, the Supreme Court in 2025 ruled that right to digital access and inclusive digital services is a part of Article 21 in the Amar Jain case. Personality rights, the right to control one's name, image and voice, are also part of Article 21. Right to menstrual hygiene, binding on all states and UTs. Article 21 A right to education. Article 21A Right to elementary education. This was added by the 86th Constitutional Amendment Act of 2002 and came into force on 1st April 2010. It makes free and compulsory elementary education a fundamental right for all children between 6 and 14 years of age. Note, this does not cover higher education or professional education. This amendment also changed Article 45 in DPSP and added a new fundamental duty under Article 51A. The Right to Education Act of 2009 was enacted to give effect to Article 21A. Key provisions of RT Act. 25% reservation in private unaided non-minority schools for EWS and disadvantaged groups, government reimburses cost. No detention policy till Class 8 amended in 2019 to allow detention after failure in re-examination in classes 5 and 8. Pupil-teacher ratio of 30:1. Primary school within 1 km of residence, upper primary within 3 km. Article 22 Protection against arrest and detention. Article 22 Protection against arrest and detention. This article has two parts dealing with two very different situations. Part 1 Protection under ordinary law. When a person is arrested under ordinary criminal law, they have 4 rights. Right to be informed of the grounds of arrest. Right to consult and be defended by a lawyer of their choice. Right to be produced before a magistrate within 24 hours, excluding journey time. Right not to be detained beyond 24 hours without the magistrate's approval. These protections are not available to enemy aliens and persons detained under a preventive detention law. Part 2. Preventive detention. Preventive detention is detention to prevent a person from committing an offense in the future, not to punish for a past offense. Under preventive detention, the detenu can be held for up to 3 months without any review. If detention is to go beyond 3 months, it requires the approval of an advisory board consisting of High Court judges. The grounds must be communicated to the detenu except when it is against public interest. The detenu has the right to make a representation against their detention. From the Sarfraz Alam case 2024, authorities must supply all documents relied upon in a language understood by the detenu for effective representation. Important, it is not mandatory for states to provide legal counsel to persons under preventive detention. The 44th Amendment reduced the maximum period of preventive detention without advisory board approval from 3 months to 2 months, but this provision has not yet been brought into force. Right against exploitation Articles 23 to 24. Articles 23 and 24, the right against exploitation. Article 23 prohibits traffic in human beings and forced labor. This right applies to both citizens and non-citizens, and it operates against the state and private individuals. Traffic in human beings includes buying and selling of persons, prostitution, immoral trafficking, devdasi system, and slavery. Begar is forced labor without payment. It includes physical, legal or economic compulsion to work. Bonded labor is also prohibited. Exception, the state can impose compulsory service for public purposes like military service. But it cannot discriminate in imposing such service on grounds of religion, race, caste or class. Enforcement, the Immoral Traffic Prevention Act 1956, the Bonded Labor System Abolition Act 1976, Minimum Wages Act 1948 and Contract Labor. Article 24 prohibits employment of children below 14 years in factories, mines and hazardous occupations. It does not prohibit harmless work like a child artist performing or a child working in a family enterprise. The Child and Adolescent Labor Prohibition and Regulation Act 2016 also covers adolescents between 14 and 18 years. They are prohibited from hazardous occupations though they can be employed in non-hazardous work. Pencil Portal Platform for Effective Enforcement of No Child Labor was launched by the government. Right to freedom of religion Articles 25 to 28. Articles 25 to 28, the right to freedom of religion. These form the basis of India's positive secularism. Article 25 gives every person, citizen and non-citizen, freedom of conscience and the right to freely profess, practice and propagate religion. The 4 elements are freedom of conscience, the inner freedom of an individual to determine his relation with God. Right to profess, declare your beliefs openly. Right to practice, perform worship, rituals and ceremonies. Right to propagate, spread your beliefs without coercing anyone. The state can regulate secular activities associated with religion. It can provide for social reform. It can open Hindu religious institutions to all sections, and Hindus in this context includes Sikhs, Jains and Buddhists. Article 26 gives every religious denomination the right to establish and maintain institutions, manage its own affairs in matters of religion, own and acquire property, administer property as per law. A religious denomination must have 3 conditions: common faith, common organization, and a distinct name. The Supreme Court has held that Ramakrishna Mission and Ananda Marga are religious denominations. Aurobindo Society is not. Article 27, no tax for promotion or maintenance of a particular religion. Fee is allowed, tax is not. Article 28, in wholly state-maintained institutions, religious instruction is completely prohibited. In state-administered institutions established under trust, religious instruction is permitted. In state-recognized or state-aided institutions, voluntary only. No student can be compelled without consent. Cultural and educational rights Articles 29 to 30. Articles 29 and 30, Cultural and Educational Rights. Article 29 protects the interests of minorities, but applies to citizens only. Article 29, 1, any section of citizens having a distinct language, script or culture has the right to conserve it. This applies to both minority and majority sections. So even the majority group can use this provision to protect its language and culture. Article 29, 2, no citizen shall be denied admission to any state-maintained or state-aided educational institution on grounds of religion, race, caste or language. This is an individual right, not a group right. Article 30, the right of minorities to establish and administer educational institutions. This applies only to religious and linguistic minorities. The word minority has not been defined anywhere in the Constitution. Minorities have 3 rights under Article 30. Establish and administer educational institutions of their choice. Administer institutions, choose governing body, appoint staff, admit students, set fee structure. Impart education in their own language. Article 30, 1a, added by the 44th CA 1978, the state shall provide adequate compensation if it acquires a minority educational institution. Article 32, the state cannot discriminate against minority institutions while granting aid. Now, the AMU Judgment of 2024. A 7-judge bench of the Supreme Court in a 4-3 majority overruled the 1967 Aziz Basha case and recognized AMU as a minority institution. The court introduced a holistic and realistic test to determine minority status. Government control does not negate minority character. The right to administer flows from the right to establish, including pre-constitution institutions. This significantly expanded protection under Article 30. Right to constitutional remedies, Article 32. Dr. Ambedkar called it the soul of the Constitution and the very heart of it. He said, without Article 30 to the Constitution would be a nullity. Article 32 itself is a fundamental right. But it can only be invoked when a fundamental right is violated. You cannot use Article 32 to simply question the constitutionality of any law or executive order. The fundamental right must be directly infringed. The Supreme Court under Article 32 has original and wide jurisdiction for enforcement of fundamental rights. The aggrieved party has the option to move either the High Court under Article 226 or the Supreme Court directly. Article 32 cannot be suspended except as provided by the Constitution, meaning during national emergency under Article 359, the President can suspend the right to move courts for enforcement of certain fundamental rights, but not Articles 20 and 21. The Supreme Court has held that Article 32 is itself a basic feature of the Constitution. It cannot be abridged even by a constitutional amendment. Now, the 5 writs. Habeas corpus, literally to have the body. It is issued to protect a person against unlawful detention. It can be issued against both public authorities and private individuals. Not issued where detention is lawful, by a competent court, or detention is outside court's jurisdiction. Mandamus, literally we command. It commands a public official or body to perform an official duty that they have failed or refused to perform. Cannot be issued against private individuals, president or governor, or contractual obligations. Prohibition, literally to forbid. Issued by a higher court to a lower court to prevent it from exceeding its jurisdiction. Can only be issued against judicial and quasi-judicial authorities. Certiorari, literally to be certified. Issued by a higher court to a lower court to transfer a case or to squash an order already made. After 1991, the Supreme Court ruled certiorari can also be issued against administrative authorities affecting rights of individuals. It is both preventive and curative, unlike prohibition, which is only preventive. Quo warranto, literally by what authority? It challenges the legal right of a person to hold a public office. Can be sought by any interested person, not necessarily the aggrieved party. Exceptions and special provisions. Article 33 empowers Parliament to restrict or abrogate the fundamental rights of members of the armed forces, paramilitary forces, police forces, intelligence agencies, and analogous forces. The objective is to ensure proper discharge of duties and discipline. This power is vested only in Parliament, not in state legislatures. Any law made by Parliament under Article 33 cannot be challenged in any court on the ground of contravention of fundamental rights. Article 34 provides for restrictions on fundamental rights while martial law is in force in any area within India. Parliament can indemnify any government servant or other person for acts done in connection with the maintenance or restoration of order. An important comparison, martial law versus national emergency. Martial law affects only fundamental rights. Suspends the government and ordinary law courts. Imposed in a specific area only. No specific provision in Constitution implicit. Borrowed from English common law. National emergency affects not only fundamental rights but also center-state relations and distribution of revenues. Government and courts continue. Can be imposed in the whole country or in any part. Article 35 gives Parliament the exclusive power to make laws to give effect to certain fundamental rights to ensure uniformity across India. Parliament can make laws on these subjects even if the matter falls in the state list. Exceptions to fundamental rights, Articles 31A, 31B, 31C. Now let us cover the 3 important exceptions to fundamental rights, Articles 31A, 31B and 31C. Article 31A saves 5 categories of laws from challenge under Articles 14 and 19. These are mainly related to agricultural land reforms, acquisition of estates, taking over management of corporations, extinguishment of rights of directors, and so on. Article 31B, this saves the acts and regulations placed in the 9th schedule from being challenged on the ground of contravention of any fundamental right. Its scope is wider than 31A. However, the I.R. Coelho case of 2007 is critical. The Supreme Court held that there is no blanket immunity. Laws placed in the 9th schedule after 24th April 1973, the date of the Keswananda Bharti judgment, are open to judicial review on the grounds of basic structure. Currently the 9th schedule contains 282 items, as of 2019. Article 31C, added by the 25th Amendment Act of 1971. It protects laws that seek to implement the DPSP in Article 39B and 39C, distribution of ownership and control of material resources, and prevention of concentration of wealth. The 42nd Amendment of 1976 tried to extend this protection to all DPSPs. But the Supreme Court in the Keswananda Bharti case declared that extension unconstitutional. So Article 31C only protects Article 39B and 39C, not all DPSPs. Constitutional rights and significance. Besides the fundamental rights enshrined in Part 3, there are certain other rights contained in other parts of the Constitution. These are called constitutional rights or non-fundamental rights. The key difference: for violation of a constitutional right, the aggrieved person cannot go directly to the Supreme Court under Article 32. They can go to the High Court through an ordinary suit or under Article 226. 3 important constitutional rights. First, right to property under Article 300A in Part 12. It is now a legal right. No person shall be deprived of his property except by authority of law. Second, right to vote under Article 326. The right to elect members to Lok Sabha and state legislative assemblies based on adult suffrage. This is a constitutional right, not a fundamental right. Third, right to trade and commerce throughout the territory of India shall be free, Article 301 in Part 13. Let us now cover the significance and criticisms of fundamental rights important for mains. Significance: fundamental rights constitute the bedrock of India's democratic system. They provide the conditions necessary for individual liberty. They protect minorities and weaker sections. They strengthen secularism. They ensure the rule of law. They check the absoluteness of government authority. From the handwritten notes, rights without duties are like men without shadows, Sir Ernest Barker. And in Indian context, rights and duties are correlative. Criticism: they are subjected to excessive limitations and restrictions. Critics like H.B. Kamath and Jaspat Roy Kapoor said the chapter should be renamed Limitations on Fundamental Rights rather than Fundamental Rights. There are no social and economic rights, no right to employment, social security, rest and leisure. The language is vague and ambiguous. Parliament can curtail them, they are not permanent. Suspension during emergency. Judicial remedy is expensive. Preventive detention under Article 22 is criticized for negating individual liberty. Chapter 7 Fundamental Rights Complete Recap. That's all for Chapter 7, Fundamental Rights, the most important chapter for UPSC. Go through the recap table one more time. Make sure every article, every amendment, and every case is in your notes. Drop a comment below, tell me which article surprised you the most today. PDF notes are available in the Telegram channel, link is in the description below. If this video helped you, share it with your study group. Every aspirant deserves quality content. All the best for your preparation. See you in the next video, Chapter 8, Directive Principles of State Policy.